So of course, when you look at CNN, you're going to know that they're going to have a certain bias. When you look at Fox, they're going to have a certain bias. And I don't think anyone is watching those shows thinking that there isn't a bias. If they are, I think that's kind of
naive.
so everyone knows that there's a bias. But I think to say that media companies shouldn't have a first amendment right, well, look at that means the government controls everything. It filters everything that we
Mm-hmm. So you favor the Citizens United outcome. Tina?
I don't think they even look at the amount of speech without considering who the speakers are. The whole point of having a high amount of speech is to make sure that there's a multiplicity of views, right? So people rise to the top. But if your corporation can buy all of the spots on a TV channel, you're having more speech, but you're not necessarily getting that multiplicity of views. The marketplace of ideas is supposed to be free, but in our financial marketplace, for example, we have antitrust laws. There should be some kind of regulation. And when humans are speaking, the court does take the identity of the speaker into consideration and considers that the compelling interest, but it seems a little bit arbitrary.
John, what do you do with the argument that corporations might buy up all the time? Just preempt anybody else, buy up all the available, in a local market, for example, buy up all of the available commercial time for their ad.
Are we going to really have individuals buying up time on media channels? Is always going to buy 10 seconds in your hands on TV or broadcast?
Doesn't seem like.
Right. So I don't think that. They're going to have more time. I do think that the truth is going to the top where whatever that's going to go to the top. But you're always going to have someone. You're always going to have someone that has more power than somebody else. And I don't think you can ever have a level playing field. So to scrap, to completely do away with media having the first amendment right because of that, I don't think that.
Sophia?
I was just going to say, to play devil's advocate to the multiplicity of ideas, comment that I think that the democratization of media makes TV, especially for my age group and my relevance, less important. And I find myself going to very specific niche media sites and social networking to get a lot of my opinions from individuals around me. So in a lot of ways, for my friends and people whose opinions I read on a daily basis, their monetary value has minimal impact on mine. So the amount of money they put into advertising and everything.
Is the point that you don't get your information from television like the older generation does, so it's kind of irrelevant to you. But corporations can put a lot of ads online too. Well, you certainly don't want it. Government shouldn't be involved in that process, right? Everybody can agree on that. The government should not weigh in on one side of a dispute.
And humans know that the government is rising level playing field. I mean, that's still government involved in speech, and it's not necessarily, or I might have a hard time calling that free speech.
Yeah, well, but recognize that speech is not never absolutely free, and there are always going to be government restrictions. And the question is the restriction justified by the need to keep corporate money from contaminating our politics? Yeah. I don't know. Look what happened in Iowa and in New Hampshire and in South Carolina just in the last month, where ads attacking one or another of the candidates seem to sway large numbers of voters. I mean, it looks like they do, at least among those people who vote. Sam?
As far as the distortion part goes, also, it's worth noting that money is always in politics. Like super PACs, look at the super PACs, all those things. Corporations always find a way to get their money in. Make the case. They said, just take out the middleman, let corporations spend directly instead of doing all kinds of things.
Yeah. They've always had to disclose. Yes, yeah, on these kinds of independent expenditures of corporate money attacking or supporting a particular candidate. The disclosure laws survived Citizens United. Come back to that. Well, go back to the beginning, because you've got on the court two justices whose judicial philosophy is originalism. That is, the Constitution should be interpreted according to what the framers of the Constitution understood it to mean, which requires some delving back into history to figure out what they meant. By the way, when the Constitution was written in 1787 in Philadelphia, it was done behind closed doors, in complete secrecy. There were no reporters there was no public there was no court reporter there was nobody to record the debates on the fundamental rules of our society. James Madison went back to his room after each session and wrote out his notes of what the debates were, who said what, and so on, in a very summary fashion. And those are the best record of what the delegates to the Constitutional Convention thought they were doing. Those notes were never published until after Madison's death, 50 years after the Constitution was written. So there isn't a good legislative history of what the framers thought they were doing in enacting any provision of the Constitution, and in particular the First Amendment. You don't have very much. And Justice Stevens provocatively included a whole section of his dissent dealing with the original understanding, pointed directly at Scalia and Thomas, the originalists, and saying, look what the framers were thinking about corporations. They distrusted corporations, deeply distrusted corporations, were fearful that corporations would dominate economic life, at least. The framers were cognizant of the characteristics of a corporation that exist today, that corporations don't die. They have perpetual life, that they have limited liability. You can't go after the CEO's house or cars and so on when you win. It's all sheltered by the corporation. That they have the ability to accumulate through various means, large aggregations of capital, which they can use that individual people can't do. And Justice Stevens noted the 18th century fears of soulless business corporations. Thomas Jefferson said he hoped to crush the aristocracy of our moneyed corporations, which dare already to challenge our government to a trial of strength and bid defiance to the laws of our country. Justice Stevens says it was not the corporations, it was the free speech of individual Americans that the framers had in mind. By contrast, corporations are people. They have no consciences, no beliefs, no feelings, no thoughts, no desires. They are not themselves members of we the people. they can't vote, by whom and for whom our Constitution was established, which in turn provoked Justice Scalia, joined by Thomas and by Alito, to respond by a separate concurring opinion about the original understanding. And Scalia said, well, all you got to do is look at the text of the First Amendment to discern its meaning. It doesn't exclude corporations. It says freedom of speech without any distinction made about who the speaker is, and certainly doesn't exclude corporations. And he rummaged around in the history of the founding period and couldn't find any. Yes, he admits that the framers were distrustful of corporations, but there wasn't anything specific to say that corporations shouldn't have free speech rights. And so he says, well, Stevens couldn't even point to a single instance where a framer said anything like that. Stevens says Scalia can't point to a single instance which said that they wanted to have corporations be speakers. Complete standoff as far as I'm concerned. And this pissing match was interesting, but it doesn't establish what the original understanding of the framer was about corporate speech. Corporate speech snuck into our Constitution by accident, by fluke. And the case where it all started was in 1886, in a case involving the Southern Pacific Railroad, where the railroad was objecting to a new tax imposed on it by the state of California. And it argued that it was denied equal protection of the law under the 14th Amendment, which protects any person from a deprivation, from a denial of equal protection of the law. And it argued that it was a person, it could sue and be sued, it was a legal, fictional person, separate from the individuals who worked for it. And the court refused to hear argument on the issue, and it's unclear exactly how this unfolded. The Chief Justice seems to have said to the clerk of the court, we don't want to hear argument about whether corporations are persons, we're going to assume that. And they went ahead and decided the case. And then a couple other railroad cases came up soon after that, where they just glossed over the issue. And by the end of the century, by 1898, the court was able to say, casually, that it is now settled that corporations are persons within the meaning of the Equal Protection Clause, the 14th Amendment, Equal Protection Clause. Carl? That's right. Well, you know, it's not a silly question, because there was a lot of coziness between the railroad executives and the Supreme Court justices. And one of them was a senator and was involved in appointing Supreme Court justices. There was a lot of stuff. There was some smoke there. Whether there was fire, I don't know. But the court still, to this day, would go back and cite this Southern Pacific Railroad case as the precedent that establishes corporate personhood. The 14th Amendment itself doesn't really, the Santa Clara case was this one, the 14th Amendment itself uses the word person 5 times in the amendment, and it's very clear from the context that the amendment was referring to natural human beings. That is, citizens are persons, not corporations, born or naturalized. A corporation can't be born or naturalized in the United States. Then there's the Due Process Clause. No person can be deprived of life, liberty, or property without due process of law. Admittedly, that's not very clear that it would exclude corporations. Same thing with the Equal Protection Clause. But then representatives, for the purpose of being elected to Congress, the number of representatives are apportioned by the number of persons, excluding Indians, not taxed. So that clearly refers to individual human beings. And then there's a ban in the amendment on persons holding office. Corporations can't do that. If they had engaged in rebellion, that is, if they had been part of the Confederacy. So the text of the 14th Amendment, which the Supreme Court has never paid any attention to on the question of corporate personhood, would seem to indicate that the court's wrong. Fifth Amendment privilege, I ran out of space here, but as, who's it back here? What's your name? Sam? As Sam points out, corporations can't, not only can't vote, but they can't exercise the Fifth Amendment privilege against self-incrimination. The court has decided that in several different cases. The Fifth Amendment, like the 14th, refers to a person. A person can't be compelled to testify against himself. The Fifth Amendment privilege. So there's all this that indicates that corporations ought not to be considered persons for constitutional purposes, and yet they are. I think it's somewhat difficult now to roll back the clock and say, well, Santa Clara was wrongly decided in 1886, and in fact corporate personhood doesn't exist as a constitutional concept. Corporations are not persons. That would mean, for example, that a state could pass a law that says that only corporations that have registered Democrats as chief executives will be allowed to operate in the state. And the corporation doesn't have any due process or equal protection right to oppose a law like that. What about all the media corporations, which covered that before, and their right to speak whether in elections or not? And I wouldn't rush to give News Corporation any special preferred status under the First Amendment by saying that, well, the First Amendment ought to be limited to media corporations. The court has never said that the press has rights that individuals don't have. The court did not say in Citizens United that corporations have identical speech rights as individuals, and I think that a thorough re-examination of the nature of corporations and how they fit into our constitutional scheme is long overdue. I think that they have different characteristics from we the people, and that those different characteristics ought to allow government to impose some restrictions in electoral campaigns. We're not through with Citizens United. There's still some cleanup to do, including where did super PACs come from? But we'll clean that up on Tuesday and then plunge ahead to other stuff we're going to do.